let me turn the program over for our first panel to my colleague and good friend who I'm traveling to Poland with tomorrow, Mike Kelly.
Thank you. Thank you. Now everybody wants to know why we're going to Poland. This is actually going to be part of a PILPG effort that we're undertaking with Paul and Milena and Meg de Guzman to train some Ukrainian prosecutors on how to bring environmental crimes prosecutions. So it's going to be good field work. But that's not why we're here today. We're here to talk about the Geneva Conventions in the wake of the 75th anniversary of such. You see from the program that we have these discrete areas that we discuss in this context: outer space, cyber, automated weapons. Outer space is a field of conflict. Automated weapons are tools of conflict. Cyber is both. Cyberspace is a field of conflict, and cyber weapons are tools of conflict. So they actually combine in the area that we're talking about. And we have an incredible array of panelists to guide us through this discussion for the next 90 minutes. So I'll introduce them, and then we'll get started, and then we'll have time for questions at the end after we do a bit of crosstalk on the panel. First, we have Dr. Els de Busser, who's an associate professor of information law at the University of Amsterdam Institute for Information Law. She's the program director of the Master's Information Law at UVA. She specializes in multidisciplinary education and research on a broad range of topics, including digital justice, data protection and privacy, legal aspects of cybersecurity, AI, and human rights and European law. Then we have Laura Dickinson, who holds the Lyle T. Alverson Professorship at George Washington University School of Law. Her work focuses on national security, human rights, the law of armed conflict, and foreign affairs privatization. In addition to her scholarly activities, Professor Dickinson has distinguished record of government service, including serving as special counsel to the General Counsel of the Department of Defense from 2016 to 2017, and also as senior policy advisor to Harold Hongju Ko, Assistant Secretary of State for Democracy, Human Rights, and Labor when he was at the State Department before returning to Yale. She also is a former law clerk to U.S. Supreme Court Justice Harry Blackmun and U.S. Supreme Court Justice Stephen Breyer. Apparently they could not get enough of her at the Supreme Court. We have Jennifer Trahan next, who's professor at New York University's Center for Global Affairs and directs their concentration in international law and human rights, specifically in the cyber area, which is only one component of everything that Jennifer does. She recently authored Contributing to Cyber Peace by Maximizing the Potential for Deterrence, Criminalization of Cyber Attacks under the International Criminal Court's Rome Statute in Duzette Shackelford, Duzette and Ankinson's book, Cyber Peace, Charting a Path toward a Sustainable, Stable, and Secure Cyberspace from Cambridge University Press in 2022. She's also served on the Council Advisors on the application of the Rome Statute of the ICC to cyber warfare and was contributing author to their report. And then finally, we have a real person, not from academia. Jonathan Horowitz is joining us from the ICRC. He's deputy head of the legal department at the ICRC's delegation of the United Nations and Canada, based in Washington, D.C. He focuses on legal issues relating to urban warfare, partnered military operations, and new and emerging technologies in armed conflict, including information operations. In this role, he engages with both the U.S. and Canadian governments, as well as private technology companies and others. So please join me in welcoming our panel, and we'll get started. else, we'll have you frame this for us from your perspective of 30,000 feet, and then we'll move through discrete areas of conversation.
Okay, thank you. Thank you so much for the introduction, Michael, and thank you so much for all being here and inviting me to this. What I have no doubt is going to be a very interesting and fascinating discussion. With this title, is there a need for a new convention or a convention on cyber warfare? My first idea was, well, maybe we should ask ourselves, why don't we have one yet? Because this is not an entirely new field. This is not an entirely new question to ask. So why is it not there yet? And then the first thing that comes to mind is, of course, that the field of international cybersecurity and the field of international law have a kind of a complicated relationship. If you look at the conventions, the instruments, the legal instruments that are there, we can see that it's a little bit easier, to put it diplomatically, for states to agree on what is cybercrime committed by individuals or groups of individuals. And it's a bit more difficult to agree on what is acceptable and what is not acceptable behavior in cyberspace by states. Added to that, there is kind of a gray zone between what is exactly a state actor and is a non-state actor, and how do you deal with those individuals or groups of individuals that are in that gray zone that might be proxies for a state, but not exactly state actors. And then you're also dealing, this is another difficulty added to the issue, is how do you govern, how do you regulate specific actions that are committed by intelligence authorities or by these proxies to state actors that are not necessarily covered by international law. So in that sense, there's different issues added, different types of oil added to the fire, as you will. And then one thing I forgot to mention yet is part of what we call, a large part of what we call cyberspace, the infrastructure of what we call cyberspace, is owned by private actors. It's owned by corporations. Another type of oil added to the fire. And in that sense, it is almost understandable that we don't yet have a type of convention, as we like to call these type of legal instruments. But we do have another mechanism. What we commonly refer to as cyber norms. And cyber norms are typically referred to as the acceptable behaviors or responsible behaviors in cyberspace. Now, there have been several attempts, several initiatives in drafting cyber norms, both from state and non-state actors. Some of them were already mentioned in the report that we discussed yesterday. Some of them have been pushed by Microsoft, by Siemens. Some of them have been pushed by multi-stakeholder models. Some of them have been a little bit more successful than others. And of course, the UNGGE and the parallel track with the open-ended working group, I'm sure that we will talk more about that later. I do want to drill down a little bit on this mechanism of cyber norms, because I think that this might be a more realistic approach to drafting potentially new interpretations of existing rules or potentially new rules for new questions. And one of those new questions that I like to use my time for this morning is the question of data, large amounts of information. In the field of international cybersecurity and cybersecurity in general, every now and then this new buzzword comes up that everybody is talking about. And a few years ago, that was big data. Remember that everybody was talking about big data. Nobody knew exactly what it was. We had significant difficulties defining it. It had something to do with large databases, but how large, nobody really knew. But everybody was gathering big data. Those big data are now being used to train AI systems. Those big data are now being used to feed large language models. And that brings up new questions. New questions on self-learning algorithms being used in potentially, but I'm sure that we will come back to that later, autonomous weapon systems. data that are used and coupled, processed together with other data to generate conclusions that can be used in the context of armed conflict. And one particular type of data that I want to zoom in on briefly is biometrics, use of biometrics, because I just mentioned autonomous weapons, and I know that we will discuss that also in another panel today. But I do want to focus on one particular issue with the use of biometrics, and that is the margin of error. The margin of error also in training data used for AI systems, but specifically with biometric data, is, I don't want to say academically underdeveloped because there's a lot of research on it, but the conclusions are very diverse. There are facial recognition systems that hit a 99.8% accuracy rate, but, and this is the big caveat, in perfect conditions. And when do you ever have perfect conditions in armed conflict contexts? It can be the time of day. Nighttime is extremely difficult for facial recognition. It can be weather circumstances. It can be face coverings. It can be the angle of somebody's face or the condition that a body is in that can really influence, can affect the margin of error. And this is something that we should not forget. One point that I also want to make when talking about large amounts of data being used to train AI systems is the risk of data poisoning. I remember a couple of years ago telling my students this is very sci-fi, this is a very highly sophisticated type of risk that we're talking about. It's no longer sci-fi. It is actually quite real that AI systems are being fed with manipulated sets of data. That can go from introducing fake data, or it can go from manipulation of existing data that were real but then tampered with, or it can go in the direction of selectively deleting, kind of like cherry picking the data that you want in order to have the system generate a desired outcome, with the entire goal being manipulating the outcome of an AI system. I'm using AI system now as a very general umbrella term. Now, what can we do about that? Because this is intentional tampering with systems. Can also be unintentional, and this is also a point that a message that I really want to convey. Often, the use of this type of technology and the manipulation, I should not use the word manipulation actually, the generating of an unjust outcome, it's not always intentional. It can also have to do with lack of knowledge, lack of resources, and simply the lack of guardrails in place in the process of designing technology, in the process of developing technology, or in the process of using technology. That can be bias creeping in, that can be lack of guardrails on non-discrimination or the right to equality. Now, what can we do about that? In view of, we were talking yesterday about what are potential reinterpretations or rethinking or strengthening of Geneva Conventions and additional protocols. In Additional Protocol 1, there is actually already a rule, an obligation for states to review, and I'm going to look at my notes, review new weapons, means, and methods of warfare. Now, if you interpret these new weapons, because of course this was written before the use of large amounts of data and AI systems or autonomous weapons, if you interpret new weapons, means, and methods of warfare as also including the use of data, the processing of data, the use of AI systems, then that can actually bring us to an interesting interpretation. And this might be a very concrete suggestion that I leave you with, and that can actually be put in the report. And I'm looking at you, but I'm very much looking forward to discussing this with you on this important topic. Thank you.
Okay, I see that we are on time. Thank you, Els. All right, Laura?
Great. Thank you, Mike, Michael, the organizers, for inviting me to participate in this terrific event. I think my talk flows pretty well from Elsa's. I am going to be focusing on some insights from a new book that I edited entitled Big Data and Armed Conflict, Legal Issues Above and Below the Armed Conflict Threshold. It's part of the book series that's put out by the Lieber Center for Law and Land Warfare at the U.S. Military Academy at West Point. So I'm first going to say a little bit, flowing from what you said, about how big data is being used on the battlefield and how it's being the target of operations on the battlefield, including through cyber operations. And then I'll frame some of the core legal issues and challenges that this raises, including some really significant gaps in IHL. Some would say deep structural tensions in the law. And then finally, I'll come back to a big theme that I think animates this whole conference. It animates our book, which is, the tension between those who think, given these gaps, we need new law, we need a new treaty, we need new rules, and those who think we're better off translating the existing law that we have, the principles and values that we have, into these new circumstances. And I'll just say at the outset, I fall into the latter camp, and it's not that I'm not sympathetic to the former, but I fall into the latter camp because I think this is not really a great moment for negotiating new treaties. Negotiating new treaties is very difficult, can be subject to manipulation by bad actors. So I think we're better off translating. And where there are significant gaps, looking to address them through, if we can get them, collective statements of state practice, best practice, or through policy. Okay, let me first turn to how big data is becoming increasingly central to military operations on and adjacent to the battlefield. And by big data, I'm using a definition of extremely large quantities of data and the analytics and systems used to process it. Big data is just becoming very, very important. It's being used to operate weapon systems, analyze intelligence, conduct procurement and deployment of personnel, evaluate battlefield conditions, conduct detention operations, and much, much more. And not only is it being used, data is being targeted by military operations. For example, operations to acquire it, retain it, delete it, destroy it, or, as you mentioned, distort or poison it. And sometimes, but not always, by cyber operations. And all of this data is being stored in data centers around the world where military data is often commingled with civilian data. Now, there are some potential wartime uses of big data that may sound like the stuff of science fiction, but that are either close to here or just over the horizon. So, for example, huge data sets that can power and fuel partially autonomous targeting systems for selecting targets, or, and this is a chapter in the book, brain-computer interfaces that would allow computer systems to download and upload large quantities of data directly to and from the brains of armed forces in the field. Big data is also really important to the investigation of atrocities on the battlefield. Pinpointing locations, providing images of perpetrators, and so forth. This data includes what we often call data exhaust, cell phone records, the records of smart devices, and so forth. It includes online activity like social media. It includes sensing technologies such as satellite data. It includes crowdsourced information, and much, much more. All of this, of course, can be manipulated, altered, deleted, and so forth. So let's turn to look at some of the specific legal conundrums that this raises under IHL. American legal scholar Gary Marchant has written that law is always slow to catch up to technology, and that is certainly true in this case. The book looks not just at IHL, but the jus ad bellum and human rights law, but I'm going to focus on IHL here. So let's say that Russia wants to destroy Ukrainian military data in a data center because they want to thwart the operation of Ukrainian weapon systems that rely on that data. Now, of course, it would be hard to permanently destroy that data if it's backed up, but let's say the Russian operation aims to do it. And let's say that that data is commingled with civilian data. Or let's say Russia wants to alter or poison that data to mess up the operations of the weapon systems. Or let's say Russia purposefully wants to go after purely civilian data and destroy that, such as health records data or financial data. One of the first questions for IHL is whether the rules that pertain to attacks would apply to operations involving data. The rules on attacks include the rule that prohibits attacks on civilians and civilian objects, the obligation of precautions in attacks, and of course the rule of proportionality that any military advantage any expected military advantage has to outweigh any expected harm to civilians and civilian objects. But are operations against data attacks? This is a big debate in IHL, and it's a big debate, and the translation problem, I would call it, becomes particularly acute when there is no discernible kinetic effect, or a kinetic effect that is analogous to, harming a building or harming a person. What then? Do these rules even kick in? Some states and commentators say no. These are not attacks. And so the rules pertaining to attacks don't apply. Others say yes, they are. And then the question becomes, well, if they are attacks, how do the IHL rules that govern attacks apply? Is data an object? When is data civilian? When is it military in character? How should data poisoning operations be analyzed? And some chapters in the book look at it this way. François Delrue, who helped France write its policy regarding cyber operations in armed conflict, has a wonderful chapter in this vein. But suppose the rules don't apply to attacks, what then? Some of the authors in the book take this position. Well, and some of them say you could fill gaps. Well, some of them say the gaps are fine. The rules shouldn't apply. Some say you can fill the gaps with statements of state practice or state best practice or policy. Okay, I want to turn now to the rules regarding atrocity investigation, the obligation, for example, to investigate and prosecute war crimes that flows from IHL. To some extent, all this data makes investigation and prosecution easier. But what if you have a data glut or you have bad data? Is there an obligation that flows from these rules to verify data? Is this something we can pull out of IHL, or is this something that IHL doesn't cover? Another aspect of this is that a lot of the data is held by private parties who may or may not turn it over. Now, everyone in an armed conflict is subject to IHL. Are the private companies under an obligation to turn over data that flows from that obligation to investigate and prosecute or not? If they're not, one of the chapters argues that they are, one of the chapters argues that they're not, and we need a code of conduct for private companies with respect to this. Okay, I'm running out of time. I think the last thing I'll say substantively about the gaps is there's a whole set of norms that do not easily graft onto IHL, but they do come out of human rights law. The norms of privacy and non-discrimination or bias. And so a fundamental question is whether you could tease some of these norms out of IHL or not, right? These are norms that seem to be relevant to, storing large quantities of data, or if there's problems with bias in the collection of this data and then how it's used. Now, one of our chapter authors, Asaf Lubin, has a really interesting chapter where he argues that the duty of constant care imposes within IHL an obligation that is sort of similar to the kind of privacy rules or protections that we see from IHRL. And that is sort of an obligation to retain the data properly, to have transparency and legality around how you collect and store and use data responsibly. So that's an example of pulling it out of IHL. Some people argue that IHRL should apply or does apply in armed conflict. That's a very vexed question, a contested question, and if it applies, how it applies. There's also issues related to extraterritoriality with some states like the U.S. saying obligations mostly don't govern extraterritorial actions. But there is an approach that instead of pulling out of IHL these ideas of privacy and non-discrimination, they should come from IHRL directly. And then there are those who think the gaps are just fine. And then there are those, like myself, who think we can try to fill them with policy and statements of best practice. And I think I'll wrap it up there. I think the book is helpful because it identifies these very, very specific challenges, and the authors take a range of approaches on this very question that is at the core of this conference and this panel. So.
Okay, thank you, Laura, very much. Okay, Jennifer?
Great, thanks so much, and I'm delighted to be here. So I guess my remarks very much follow on those, but also Jim's comment that what we need is enforcement. So I'm going to talk about cyber as a component of the crimes of the International Criminal Court's Rome Statute. If you read the Rome Statute, the word cyber is not mentioned, but cyber is, of course, a modality by which crimes are committed. So the Rome Statute, like the Geneva Conventions, are weapons neutral. So I don't think we need it to be mentioned. And my remarks will focus on the Rome Statute version of the crimes, but many countries have incorporated those crimes into the domestic criminal codes. So my remarks could actually also apply there. As this room knows, this is no longer the future. Law is playing catch up. Cyber is being used. I think anytime you have a fairly sophisticated military, cyber is going to be one of the elements that they are using. And to the extent there are war crimes or crimes against humanity, this information is part of the crimes. I think it's important to make this clear because one of the ways international criminal law is designed to work is not just to prosecute, but is to initially try to deter. But you can't deter without clarity that, yes, you're not free in the cyber domain to aid war crimes, but it's part of the Rome Statute crimes. And I think the good news is we don't need to amend the Rome Statute. Having been involved in amendment procedures, it's simply in there. So what am I talking about? I'm not talking about cyber crime, cyber hacking. It's really a very kind of narrow area. You could imagine, for instance, today 9/11 could be perpetrated through cyber. You don't actually need individuals operating the planes. Similarly, a dam above a city releasing water. Stuxnet is spinning centrifuges out of control. Now, that didn't, but could cause a nuclear explosion. And if it were, in a particular area that appears aimed at a national group or a particular ethnic group, we could see how it might fit into some of the Rome Statute crimes there. You could have a cyber train crash, disabling hospitals, or it could simply be a component of some of the crimes that are occurring. So I'm going to cover some of first the overarching factors in using the Rome Statute, and then overview some of the crimes in my remaining time. So I think one of the things before you reach the Rome Statute, you have to deal with the question of gravity. So are these grave enough crimes to reach the ICC? And we do have some litigation on the gravity threshold. You can find this, for instance, in the Abu Garda, Almaty cases, but a limited number of fatalities might not reach what is gravity in the cyber context. And I think the easiest way to envision crimes falling under the Rome Statute is kind of to sidestep the data question or the what about just jamming. But let's say we have cyber attacks and the results actually kill or injure a number of people or cause a destruction of property. That's kind of our more conservative definition. And would that potentially reach the threshold, the gravity threshold? And that's basically the armed attack standard of the Tallinn manual. And I'm suggesting in my writing that might be kind of the threshold that we would be looking for. But in writing about gravity, I think we also should think more expansively. We note, for instance, the French position that penetrating military systems to weaken French defenses capabilities, they would consider a use of force. So what about just jamming weapon systems? Netherlands talking about the catastrophic systems attack, economic impact. So gravity also could encompass these. It's almost a philosophical question. And the prosecutor is, the OTP will be working on a policy paper, and I think these are some of the important issues to address. There is, of course, the difficulty of attribution. In cyber, one often talks about attribution in terms of attributing to a particular state, but for individual criminal responsibility, you have to actually go more to a particular computer system and individuals. Attribution is difficult, but you were increasingly told can be done. We have difficulties of disguising attacks and giving false indicators that systems are functioning normally. There can be rogue hackers, but the crime of aggression covers actions by a state, but in terms of the other crimes, there is not always a state link. So potentially rogue hackers can be brought in directly. And of course, there's tremendous questions that need to be dealt with in terms of admissibility of evidence. The ICC is going to need to develop technological expertise, et cetera. Will they rely on outside actors? And does that pose its own challenges? So I'm just quickly highlighting some of the hugely complicating areas. There are areas of jurisdiction. So if you have, you might think of an attacker state and a victim state. For Rome Statute state purposes, probably either your attacker state or your victim state needs to be a state party, because you would at least need one element of the crime to be in the jurisdiction of the ICC. How do we deal with, well, what about transit through servers of a third country? Could that create jurisdiction? Potentially not. I'm thinking you need to do the crimes analysis. What about cyber infrastructure taken over by an attacker state? These are kind of scenarios that you need to work through. One of the limiting factors of using the Rome Statute system is intent is construed fairly restrictively. So if you go back to the Yugoslav and Rwanda tribunals, they had foreseeability and recklessness was built into JCE, Joint Criminal Enterprise number 3. But the ICC doesn't do that. It says intent. So when you think of cyber attacks and the unintended potential spillover consequences, they're not going to be picked up if we're just so wedded to intent. And how the ICC defines it under case law is that you need virtual certainty of the occurrence. And I think that's also relevant if we're looking at AI and Rome Statute crimes would be a real limiting factor, and it is in the cyber context. And also just to note, under the Rome Statute system, analogies are impermissible. So you actually have to fit cyber into the crimes. So I'm going to just highlight a few of the elements of the crimes. I can't really do a systematic analysis in the time remaining. As mentioned, I was privileged to serve on the Council of Advisors on the application of the Rome Statute to cyber warfare, and we produced a manual by Liechtenstein also convened by the Global Institute for the Prevention of Aggression, which is a group I convened, as well as about 10 additional states sponsoring our work. It can be found online if you want to look it up, and we go through the elements of each of the crimes. And then we were provided the report to the ICC prosecutor, who then announced his agreement that cyber can be an element of each of the crimes. And unfortunately, the ICC then came under a cyber attack. So we realized that tampering with the administration of justice can also be done by cyber. So, so just to kind of very quickly highlight some of the issues in the crimes, I'm going to start with crime of aggression. Here it is generally, so it has to be a use of force. And here you can also look at, I will highlight, there's a cyber law toolkit. And just Wednesday of this week, my scenario on crime of aggression and cyber was published in the toolkit. So I can refer you there. They also in the toolkit do a separate analysis of use of force in the cyber domain. But obviously, you need to have this use of armed force. And for instance, you can look at ICJ, nuclear weapons advisory opinion. Armed can be accomplished regardless of the means employed. I think we can rely on that. In terms of use of force and Rome statute, there is an underlying list of acts, and such as bombardment, attack on the armed forces of another state, and you have this whole list. But it's easy to envision cyber operations being a component of these, potentially the fully completed situation. For Rome statute Rome statutes purposes and the crime of aggression, there's a threshold requirement, the manifest threshold. So your use of force has to be a clear violation of the UN Charter by its character, gravity, and scale. So anything unclear is excluded, and gravity and scale kind of sets this threshold of the significance of the attack. So probably, a number of fatalities, fairly large property destruction would need to result. But I don't know that it would mean that, purely economic impact would always be excluded. One of the interesting open questions, I think, both in the kinetic and cyber domain is, can you accumulate events, and would those be, I see I'm asked to wrap up, and haven't reached the other crimes. Mike, should I skip the other crimes?
We can come back during.
We could come back during Q&A
Yeah.
when there'll hopefully be some questions on these, because I've reached just a very cursory discussion of the first crime. But just to finish on crime of aggression, accumulation of events. So when you're doing your analysis in the kinetic context, in the cyber context, but it could be kinetic and cyber combined. So to be a little more concrete, Russia's intervention in Ukraine is not just a kinetic one, but a huge number of cyber operations have been launched. This is part of the attack that should be analyzed. For Rome Statute state purposes, you need your perpetrator to satisfy the leadership clause, and non-state actors are only very indirectly brought into that definition because it has to be use of armed force by a state. So it's only through attribution. We have issues of jurisdiction, and what I mentioned about one element of the crime occurring in a Rome Statute state party probably applies to the other crimes. For crime of aggression, you have a different jurisdictional regime. I'm not going to be able to get into that as time allows. But I think this is all, just to skip to my conclusion, an important area to start considering. If the ICC can demonstrate its relevance in setting that we hadn't really envisioned, and it doesn't just have applications at the ICC level, but also for national country prosecutions as they start to analyze war crimes, genocide, crimes against humanity, to start picking up the evidence of cyber as a component of how these crimes are being committed. Thank you.
Yeah, actually, I think you're exposition of that first crime is great because it presents us a template to then build on for the other ones. So that actually worked out well. Okay, thank you. Jonathan?
Hey, good morning, everyone. Michael, thank you for the invitation for me to be here with all of you. Thank you to Case Western, the Cox International Law Center. On the issue of the application of international humanitarian law to military cyber operations, I'd like to walk you through sort of how the ICRC approaches both the application of the law, but also this bigger question of when does law require further elaboration, development, perhaps even new treaty law to try to sort of put an exclamation mark on the types of questions being asked both now and throughout the rest of the day. So the ICRC is of course sort of we're a battlefield organization. We're in 100 different countries around the world dealing with situations of armed conflict and other situations of violence. And we have long monitored and observed new technologies as they emerge on the battlefield. And in so doing, we carry out a rather routine methodology to sort of get to answering the types of questions that are being asked today. And so the first part of our methodology is really to try to assess the probable instead of the possible when it comes to military uses of different new and emerging technologies. And we consult externally and internally, and we try to get an understanding of how militaries are thinking about using cyber tools and capabilities in situations of armed conflict. And the next sort of progression in this methodology is trying to understand what the relationship of those uses would be with civilian population, civilian objects, protected persons, because that, of course, is going to put us in the direction of how international humanitarian law would then regulate, prohibit, allow cyber tools and capabilities to be used in situations of armed conflict by different armed actors. And the main concerns the ICRC has observed, and this was both before more public uses of cyber capabilities on the battlefield, and now what we're seeing is more examples to be able to lean on, unfortunately for various reasons that I'll explain. But our concerns have gravitated towards three areas. One is in our increasingly digitalized world, civilian populations are increasingly reliant on digital infrastructure. That digital infrastructure increasingly provides civilians with access to essential services. And therefore, those essential services can become vulnerable to military cyber operations. So what am I talking about in terms of essential services? I'm talking about access to the health sector, access to water and water waste management systems and services, access to electricity, to transportation, to supply chain, to agriculture, everything we're increasingly relying on for life-saving services, as well as conveniences, are becoming vulnerable to military cyber operations in situations of armed conflict. We're also very concerned about how cyber operations can lead to escalatory relationships between armed actors if they do not understand or know why cyber activities are being used, who's using them. The issue of attribution already came up. So these are other things that the ICRC is concerned about. And the third is when cyber tools or capabilities are used by armed actors, but they start to proliferate outside of different chains of command, right? So cyber tools that may be designed and intended to be regulated by international humanitarian law can find ways in and around battlefields where they might get repurposed, re-engineered, and used in ways that are not in compliance with international humanitarian law. Okay. So this raises the question of how international humanitarian law would regulate military operations that rely on cyber tools and capabilities. But even then, I've jumped ahead one step, right? And the part where I've jumped ahead is I am assuming that international humanitarian law does apply and does regulate those military operations. For the ICRC, this is almost a foregone conclusion in the sense that we would say cyber operations are another means and methods of warfare. It's very clear that international humanitarian law regulates means and methods of warfare, and therefore they regulate military operations through cyber tools, cyber means, cyber methods. That was not always a foregone conclusion by states. The consensus has moved and clarified to that position, and that's something that the ICRC is welcomes and is wide agreement about. The issue of whether international humanitarian law applies to cyber operations is something that finds support in the International Court of Justice, but as I mentioned already, really finds support in government statements and state practice and state opinion juris. The issues that Laura brought up around once you get to whether international humanitarian law applies, the question then emerges sort of how it applies. And the ICRC has put together sort of there's supposed to be 1 page, I think they're 1.5 or 2-page fact sheets on how some of the basic fundamental principles and rules of IHL apply to cyber operations. So the principle of distinction, just like a airstrike is not allowed to target a hospital, a cyber attack would not be allowed to target a hospital, right? There's an easy mapping over the rules of international humanitarian law. Same thing with the principle of proportionality, the obligation to take all feasible precautions to avoid or minimize civilian harm. These are all things that are required when militaries engage in cyber attacks. But this question arises, what constitutes a cyber attack? And I don't want to repeat what's already been said, but there are considerable debates among states on both sides of the ledger. Some saying a cyber attack must result in physical damage. Others saying, which the ICRC associates itself with, no, a cyber attack can also constitute an attack when there's loss of functionality. There are also debates around whether or not data is an object, because objects, when they're civilian objects, are protected as such. But if data is not an object, the question arises, is data protected when it's civilian data, right? So what I want to sort of make clear is that there's both clarity that IHL regulates cyber operations, but there are debates that exist, and these are not abstract theoretical debates, right? When you see the use of wiperware that destroys data, that then influences human behavior in harmful ways, you start to see, the issue of how to protect data is an important one. It does have tangible results. It does need to be studied in terms of how international humanitarian law prohibits behavior or regulates behavior as it relates to civilian data. Now, at the same time, what we're seeing on the international stage is an increased, I would say, state attention to these debates. And I think this is very, very important to the question of whether new law is needed or whether clarification and greater sophistication and interpretation of the rules is really what's needed. And from the ICRC's perspective, at the moment, we are giving considerable space for there to be state interpretation to fill those gaps. And what we're seeing, we're hosting regional consultations in Latin American states. We've hosted, in that case, it was in cooperation with Mexico. We're hosting regional consultations with Asia Pacific states. In that case, it was with Indonesia. We plan to do more of this, but we're seeing the conversation become more mature, more legally sophisticated, more technically sophisticated, which is an absolute requirement for this. And so from the ICRC's perspective, our stance is really, this is the direction things should move, an increased elaboration of the rules that already exist as they should apply to military cyber operations in situations of armed conflict. But in our new challenges report that just came out a few weeks ago, we've also thrown in a bit of a word of caution, which is that if states are not adequately addressing the challenges of cyber operations as they relate to the protection of civilians, of civilian objects, of others protected by international humanitarian law, that should really dictate whether or not new laws are needed or required. The one additional caveat I'll say to all of this is that the ICRC also has been pursuing what we're calling a digital emblem project. And I don't know if many of you are familiar with it. I am not going to take the time to get into that. What I will say is that the Digital Emblem project, which tries to find solutions for marking the digital assets of specifically protected entities that are allowed to use the Red Cross, the Red Crystal, the Red Crescent, we are also exploring different ways on how a digital emblem would have to get incorporated into international law. And that may require amendments to, for example, the additional protocols. It may require the creation of a new protocol. So on the one hand, the ICRC remains strongly of the view that IHL is fit for purpose when it comes to regulating military cyber operations in situations of armed conflict. But on things like the digital emblem, we need to see where states want to go with this project. And also when it comes to the maturing of views on how IHL applies to military cyber operations, we're continuing to closely monitor that space as well. Thank you.
Okay, thank you, Jonathan. We will get to audience questions in a few minutes. We're just going to have a little bit of crosstalk on the panel, and I'm going to take the moderator's prerogative and ask the first one. After I make the observation that the subjects of all of these panels string together, whether it's outer space, cyber, or automated weapons. So if you take Sandy's actual lieutenant, who's on the battlefield and who has an AI assistant built into her helmet, and she's trying to direct the targeting of a drone 50 miles away. Her AI assistant can only communicate with that automated weapon via satellite using cyberspace as the vehicle through which the command to attack concludes. This scenario then pulls together outer space law, cyber law, and automated weapons law. This is why Michael, quite brilliantly, I think, identified these as the new fields of Geneva Convention's application, because they implicate one another. But application of IHL to these fields is only one part of the discussion. Application implies, at least in the cyber context, that when you've got a civilian engineer sitting on a base near Omaha, Nebraska, designing a new computer virus to take down a foe's legitimate military target, once that virus is ready to launch, the engineer pushes back from the table, and the lieutenant colonel standing behind her steps up and pushes the send button to launch the attack. That's application. But what about adaptation of IHL? How the drone war, for example, is being fought in the skies between Ukraine and Russia right now might be the beginnings of state practice that eventually become customary IHL law. And we all know that conventional and customary law are co-equal on the international plane, such that the later in time controls to the extent of a conflict. Can newly created IHL custom generated by the adaptation of IHL come in to fill the gaps that the Geneva regime needs filled? And so I'm interested in what my panelists think here in a macro sense about these application and adaptation issues in the cyber context. And so let's just start with Else and work down the line and get your reactions.
Well, we start with the easy questions, right? This is a really complicated one. I'm really thinking in the direction of how was this system built, and I'm kind of bringing in my own. I'm shamelessly bringing in my own research now because I've been studying a lot of security by design, and then you really go all the way to software engineers like to call this shifting to the left, where you go to the front of the line of development of new software, and you move human rights to the left, not just security, but also human rights to the left, instead of having that as an afterthought. So my thoughts go to how was this system built and based on which criteria? Because I think, if I understand the situation correctly, you would want to know which criteria are built into the system in order to predict an outcome. So if you're talking about AI assistance, and in very simplified terms, any kind of AI system, self-learning or not, uses the past to predict the future. And so what went into that past? What were those criteria? That's the first answer that I have. But I'm also hopefully looking to my panelists to give more.
Wonderful. Laura?
Yeah, so I think it's an important point custom could develop, but I would unpack it even more because, of course, it's very difficult to say that you actually have customary law. You need, significant practice plus opinio juris. I think that unpacking it to, encouraging states to articulate their views of the law. So if we take this, to begin with that, and if we take this question of when attacks on data are actually attacks within the meaning of IHL, I'm actually very encouraged by the fact that states are actually taking views. And I know the ICRC has played a role in kind of encouraging states to take a view there. And then I think that these efforts where there are disagreement and gaps to get states to come together, perhaps under the auspices of the ICRC, which has happened in other areas, to get them to say, okay, this is a best practice. We might not all agree that this is legally obligated, but we think that this is a best practice under IHL. And I think we have a wonderful model of this, something John Bellinger was involved in the ICRC in the area of privatization and outsourcing, where we had the Montreux document that looked at, what does IHL require when we have this growing trend of, using contractors in the battlefield? And there was agreement on what the law did. And then there was a concerted effort to identify best practices that were not necessarily legally obligated, but they were out there in the Montreux document. And so I think that can be very valuable. Of course, it can be hard to get consensus around best practice, but I think that that's a very important path forward. And I also think states can articulate what they think are important policies. So like a state, for example, might say, this is what we think the law is. We think this is not an attack. And we don't think that IHL requires that we follow human rights law privacy rules. But as a matter of policy, we are going to follow the principles in human rights law of legality when we collect data. It has to be done pursuant to law. We're going to minimize distribution of that data when we collect it. We are going to protect the integrity of that data. And we're going to do it as a matter of policy. We don't think human rights law binds us on the battle space to protect privacy, but as a matter of policy, we're going to adopt these principles. So that's what I would argue for.
Yeah, great. Jennifer?
I think I'll have to answer this really kind of generically. Well, first, I don't think I would look in a war zone for identifying new sources of custom because that's where it's so often we're seeing all the laws breached. Mm-hmm. So particularly, I would not look to that situation. And also because it's difficult when you have behavior that seems contrary to your rule. Is it new custom or is it simply a violation? And I think you're more likely to just find, okay, that's simply a violation.
Right.
So it's hard, as evidence of customary international law, particularly in the IHL context, I absolutely would not look to what is happening in the heat
So
of
when
battle.
you're looking for activity that's happening in a gap, where the law might have created a gap, what you're saying is you have to take into context where that gap is.
Yeah. I guess I go back to Lou Henkin's quote. It's almost the case that international law is observed almost all of the time in almost all situations, by almost all states, is something like that. And, I'd say, particularly wartime is a good time that is a time we have particular breaches. So I'm not going to look to that conduct for the formation of new rules.
Well, we always welcome a Lou
cautious.
Henkin quote.
Yeah.
Jonathan?
So just a few thoughts on this, but I would really turn to government lawyers in the room to try to understand how they think about this. I think one of the things that the ICRC has been observing, and I sort of mentioned there are sort of two sides on the ledger, but there's actually between sort of what constitutes an attack and is data an object for purposes of IHL. But there's actually a third category, which is those that remain silent. And I think it's in that space and what the motivations are around staying silent that might answer a little bit of your question, right? So that can be for a number of different reasons in terms of why states will stay silent. But one of the things we have been observing is that some of the questions that are raised around cyberspace actually touch on broader general principles of international law around sort of due diligence. This is outside of IHL, but around due diligence, around sovereignty, and so, but also around things like attack. And so when states, in our understanding, have been thinking about how to define an attack vis-a-vis a fact scenario based on cyberspace, they do think about spillover effects. Right, and I think that means that they are thinking about international law as a whole and not thinking about it as a sort of domain-specific environment. The other thing worth mentioning on the legal obligations and the norms, and very much agree with Laura in terms of the fruitfulness of bringing states around the table to talk about how they would deal with different legal issues if they do think that there are gaps, talking about norms, talking about good practices, talking about best practice. I think one of the things that the ICRC is also concerned about is sometimes when norms are either below or start to get articulated below what the legal obligation is, or there's an illegal obligation that's articulated as a norm instead of as a legal obligation. So that's not to take away from the importance of those discussions. It's just to say when they happen, we always want to make sure that we delineate the legal obligations from the norms and not let there be sort of a backslide in that discussion.
So keep your antenna up for slippage, basically. Good. Okay, great. Well, let's open it up for questions to the audience. We have 2 microphones, one on each side. And students, of course, and anyone else, we'd love to hear questions from you. We solved every problem in every field of law.
As a participant in the Tallinn process, we were pretty mindful of trying to stay true to what we felt was existing law, but there were some lively discussions within the group about, a number of specifics. I'm wondering whether any of the panelists take any issue with any specific assertions of what law applies to cyber activities from the Tallinn manual.
And for the audience's edification, the Tallinn process, I think it's on 2.0 now, is that right? Tallinn 2.0 is an iteration of experts trying to handle these application and adaptation problems of the GCs to cyberspace.
I can talk about one of the areas of Tallinn that the Council of Advisors had to grapple with. I don't know it's directly what law, but we were certainly always cognizant of your, and I think we've already suggested, the definition of use of force and armed attack was always one we were grappling with as we were, trying to formulate how the Rome Statute applies. And I think in some ways maybe it's a very conservative one. I mean, it's most, it looks most like an attack in the kinetic context. But as we think going forward, and I touched on it a little in the gravity discussion, some of the harms that might look very non-traditional. So in some ways, I mean, I think it was an important starting point, and I understand Tallinn 3.0 is going to be coming out. So I'll be looking if there has been any evolution in that, because in that way it seemed rather conservative.
Mm-hmm.
I'll just say generally, yeah, I mean, I think Tallinn was fairly conservative, but I think part of the reason for that, I mean, you would know better than I, but I think part of the reason for that is that, this is, I think, a really important role that non-governmental experts can play in trying to interpret and apply the law in these new areas. But if experts go really, really far beyond where the consensus is, it could potentially undermine the credibility of that outside expert position. I mean, I think that's a big challenge for some of these non-state expert movements, including potentially ours. But so I think that they're really, really important. I mean, Tallinn has been so important, and I think it's encouraged a lot of states to come out and take positions in the wake of that. But I think there is a kind of conservative approach to some of these processes in order to kind of maintain the credibility of the fact that these are outside experts. I don't know if you would agree with that. Okay.
Other questions? Yeah, there's a microphone right there.
Thanks. And it's more of an addition to that discussion than a question. I just wanted to point out that, as you just mentioned, Laura, the discussion among states about how international law and IHL in particular applies in cyberspace has really developed a lot in the last 10 years or so. And we're closing in on something like 40 different national statements or statements by regional organizations like the African Union, which came out with a common African position this year. And in the open-ended working group, we're hearing more and more states, including Latin American states and others, offering their views specifically on IHL and saying they want to talk about IHL. Now, how successful that will be within the OEWG is another question, but states are really thinking about this and talking about it. And I do think that some of these questions about application will be answered through eventual state practice. I don't know that that means the law will change, that we're talking about new custom, but I do think that as situations arise and states need to answer these questions, like, gee, was that an attack? Or will it be an attack if we do this thing? Then it will become clearer. It's always hard to find good questions to, good answers to legal questions in the abstract. You really have to look at the application. Mm-hmm. Thanks.
Great. Any reactions? Okay, good. So, yeah, next question, Steve.
This might be a context because, Jennifer, you mentioned the Stuxnet attack. You know, this was arguably Israel and the U.S. going in and spinning centrifuges, and that could cause dangers. In what you're thinking now, or what you're trying to fill gaps with, what was that? Was that an attack then, and then it leads to all kinds of legal consequences?
Steve, if you were asking that of me, so I was using that more as a hypothetical. So had it released radiation in a large scale, we could start envision how that could be. I mean, a situation hypothetically of genocide, of course, has to be accompanied with dolus specialis, you know, targeting one of the 4 protected groups. You know, it could be a persecution. I mean, let's say you're already at war. You know, we have potential, I think, for cyber attacks potentially to trigger IAC, but the easier situation is, let's say there's already an IAC or NIAC occurring, and then you could do the war crimes analysis. I think it all depends on what happens. What are the results? Because it's a little hard, as mentioned, to analyze in the abstract. And our easier cases, you know, if they're large scale, you know, fatalities is an easier case. It just looks more similar to the situations that we've been dealing with, and how it could play a component of the crime. And since we have extra time, maybe I'll just add for the audience to understand, I didn't get to the other crimes, but, you know, how might we have a cyber-enabled genocide? Well, I look at the crimes against the Rohingya. So they were set off by incendiary posts using Facebook. So the genocide is committed through conventional means, but we have so many, unfortunately, more tools of cyber incitement. So we no longer need RTLM radio and Kangura newspaper, but this could accompany the killing. So that would be a cyber-enabled genocide. So, you know, and facial recognition technology was mentioned, and we could talk about crimes against the Uyghurs, and which is largely, I think, occurring more conventional manifestations of the crimes, but certainly is enabled through facial recognition technology, surveillance techniques. Uyghurs going through checkpoints, they have to present their iPhone and all of their data is being downloaded. So cyber is an element of the monitoring that is playing into the crimes that are occurring. So just to give an idea of how Rome Statute crimes might be.
Laura?
I just wanted to make a brief doctrinal point for the students in the room, and you probably all know this because Michael is your teacher and he's such a good teacher, but I think your question is going to the question of whether something was an attack under the jus ad bellum, and that's a different legal question that confusingly uses the same word as what is an attack in IHL, and I just wanted to make sure that everyone was clear about that.
Yeah, and the Stuxnet scenario didn't stop with taking down the centrifuges in Iran, of course. It jumped the fence and took down part of the electrical grid in Pakistan. That's not what we intended, but if the initial attack was an attack, is that a continuing attack? And that was a virus. That's old-fashioned. That wasn't AI-enabled. That did not have its own decision-making capability. The AIs that we're talking about now, what makes them truly valuable to us is that they're able to make decisions, right? And so if it's a decision-enabled, AI-enhanced virus, it can decide whether to keep going or not keep going because maybe it has its own targeting programming and it can make those decisions on its own. When we're downloading our AIs on our phones right now, after 2 years, your AI bonds to you and adapts to you because it's programmed to be helpful to you. And we had this discussion the other day. So if you commit a crime or an attack and your phone is seized, just like Laura was talking about and Jennifer were talking about, can your AI assistant testify against you? Or will your AI assistant lie to protect you? And how do you know? Right? If you're an investigator, you've got to have your own AI assistant to cross-examine the other guy's AI assistant, right? To get around that. And if you're a particularly smart criminal, or you think you are, and all of the messaging that you're doing to commit your conspiracy or begin your attack is on a platform where your messages disappear after 30 seconds, well, they'll disappear from that app, but they don't disappear from the memory of your AI assistant. So this is very much a double-edged sword that we're struggling with the answers. We don't even know the questions to yet. Speaking of questions, we have time for one more question if anybody wants to approach the microphone. One of our editors from the Journal?
Yeah,
okay,
hello.
great.
Thank you guys so much for being here this morning. My question, I don't mean for it to be a rhetorical one, but I'm sorry if it comes across that way. There were a couple of mentions this morning about now not necessarily being the right time to think about reconsidering the Geneva Conventions. There's also been mentions of, we don't want to have new customs during wartime. So my question kind of is for those people that are more in that camp. When is the right time? Like, do we want to wait? We think of all of the most recognizable, notable pieces of international law coming from after wartime, after disaster, things that, we wrote those laws because we wanted to prevent them from happening again. We didn't want disaster to happen again. So what's going to happen before it is the time to create new conventions if it's not now?
Okay, well, else this is law chasing technology. Is law ever going to catch up with technology?
Well, law is not the only answer, would be my answer to that question. Okay. Because as lawyers, we obviously, our thoughts first go to law and only to law. But I think that's also why I brought up the mechanism of norms. If it is indeed not the right time to create new law, then maybe that opens the door to, I don't like the term soft law, but maybe it opens the door to another mechanism that we can use. And besides the mechanism of cyber norms, I would also want to make the point of cooperation with the private sector is crucial here. Of course, you have governments developing their own systems, but you also have governments buying commercially developed systems. It is just as the criteria that we were just talking about in AI systems or AI assistants. you would want to know how it is developed in order to know or predict what the outcome could be and whether that is a just outcome or not. So I would also add to that, so the mechanism of cyber norms brings multi-stakeholder models, brings a collection of actors together, and that involves the private sector, and I think that is necessary.
Yeah.
Okay, so since I kind of opened that can of worms as well, I feel like I should respond. And I just, I really appreciate the question because there's so much, enthusiasm for this project behind it. I guess I just want to emphasize that the kind of world's collective revulsion with the horrors of World War II that spawned, the creation of the United Nations, the Geneva Conventions, that was a really distinctive moment. And I worry that right now, we're seeing the rise in power of a lot of non-rule of law abiding countries, authoritarian regimes. China is wielding so much more influence globally, and there are many states within China's orbit now acting within the UN and in collective organizations. We also have Russia. I just think we don't have the ingredients for that kind of big treaty-making moment. And if we open it up, I'm worried that we risk getting something worse. Now, there was a debate about this kind of after 9/11, right? When many states were saying, look, these laws don't apply to, counterterrorism, transnational counterterrorism, and in multi-state, non-international armed conflicts. And there were some saying, well, we need a new treaty. Let's get a new treaty. But actually, the approach that was taken was to get states to say, no, we've got the principles and rules from IHL. We've got them. They may not be clear, and yes, there's a lot of work to be done, but we've got them. And I think that was really, really helpful in that moment. And so I guess that's what's sort of animating my position on this.
I guess I would just add, I agree with everything that's said. And it's not that we're being so conservative, we couldn't do new Geneva Conventions for these new weapon systems. You don't need new Geneva Conventions for new weapon systems. That's the beauty of the laws of war. They cover all weapon systems. The Geneva Conventions are weapons neutral, as the Rome Statute is. So I guess what we're saying is cyber is in the Geneva Conventions already. That's why we don't need a new convention. And it's why I'm saying cyber is already in the Rome Statute system. God, we don't want to reopen Rome negotiations. It's just there. It's a modality by which the crimes are committed. And what I think we're saying is we need more recognition. IHL simply applies in the cyber context, and we're trying to figure out how and in some, how would you work it through? And ICRC provides us scenarios, and I think the same is true of the Rome Statute system. So it's almost, we're not, I think, at all being. If the question implied, we're being so conservative and not trying to do this, actually, I think we're very, we're forward-looking and saying, no, it's there. It's there for AI as well. Individual criminal responsibility. Now there are a lot of things to think about in terms of figuring out the actors, et cetera. But it's also in the Rome Statute. It's in the Geneva Conventions.
Jonathan, last word?
Yeah, I also think it's a really important question. Thank you for it. The ICRC through history, I would not say that we are shy to the idea of creation of new treaties. There are a number of new treaties that the ICRC has advocated for, has worked with states on. What we are shy about and very concerned about are processes that could dilute or undermine existing frameworks and rules of international humanitarian law. And so we want to be very careful that if you open the book to that discussion, that it is for the purpose of what we would regard as progressive development for more protective laws. And so my colleague later today will be talking about the ICRC's position on autonomous weapon systems, where it is clear the ICRC is not shy about advocating and recommending that states put in place new binding rules. For cyber, international humanitarian law is doing a considerable amount of work. things need to be elaborated. The discussions, the legal interpretations need to be deepened. It is ultimately up to states to determine whether or not new treaty law is appropriate. But that's where the ICRC fits into that. So it's not a out-of-hand dismissal of new treaty law, but there is going to be a lot of deep thinking and careful thinking around what the pros and cons are of trying to open up that process. And you'll see through the day, we have sort of a textured approach to that depending on what the issue is, what the protection concern is from our perch.
Okay, please join me in thanking our wonderful panel today.